So I remember them showing, I forget what hearing it was, but they did show a video of when his mom came, Jeremy and his mom came to my house with the order printed out with the police. And at that time, Jeremy wasn't willing to bring Wynn back. We didn't know what the exchange was going to be, but we knew his parenting time was during that time frame. So he came and picked her up, but I had no idea if he was going to bring her home or where we were going to meet. And so his mom was pretty much doing all the talking to the police, and she was holding Wynn. And she said that I'm a liar, I'm a sociopath, I'm a pathological liar. So if you were to play the actual recording, you would hear her saying those things. I never said that about his mom. I never even, honestly, I didn't even acknowledge her. I was talking to the officer because I told him she's not the parent and I don't have a relationship with her. So I don't even know why she has a say in the matter. That's what I said to the officer. I never even addressed her, except towards the end, I did say that she was acting like an old lady. I did say that, but I didn't call her, what did he say? I said a pathological liar. She actually called me those things while holding my daughter. And that is on a recording that they have.
Okay. The $50,000 balloon note, is that related to the actual property itself? I.e., if the property is sold, you pay that 50. How does that 50,000 work?
Yes. So from what I understand, the paperwork that we signed for the COVID relief, when we sell the property, that 50,000 must be paid back to Flagstaff.
And so you got 50,000 from them.
They didn't give us 50,000. It was the amount of money that we did not have to pay during that time frame. So they gave us like a year of
without having to pay.
Right.
And that total in the year would have been 50,000.
Yeah.
So it saved you $50,000 for 1 year. That seems high. Because 2,000 times, even if you take a note, 2,000 times 2 would have been 24, not 50.
I think we did extend it. I think it went 18 months and not 12 months.
Well, even then, it seems something's up, but okay, that's what it is. Both of you agree on that. All right. Let's see, Robert K. possession. Okay. And I don't think there's an issue with the dog. I haven't heard Mr. Knowles say anything about it, but so where is lady who has the dog now? Can't recall. I have her. Okay, so you have the dog. Okay. All right. And the dog is currently in your possession right now. And y'all don't trade the dog off or anything like that, right? Mm-hmm. All right. And so I can understand that the issue with the arrow again. You said the arrow was in your name, but Mr. Knowles indicates that you haven't paid it and it's in his name. Can you explain that one more time?
Yes, so I own the account, the arrow account. We do quarterly pest control. So we've had that since we lived here in 2017. We actually just assumed the same contract that the previous owner had. So we continued the quarterly pest control, and Jeremy took out a separate, so the pest control department and the exclusionary wildlife department is two separate departments. So I have always paid for the quarterly treatments. Even when I moved out of the house, I still paid for the quarterly treatments. As a separate engagement, he hired the wildlife exclusionary department to investigate the rat activity that he mentioned. But that was while I wasn't living here.
Okay, but there was a bill that came, and the expectation, you understand, was for you to pay it since you benefited from them catching the wildlife. Is that it?
So what I understood, Judge, was that I wasn't responsible for any bills or anything that occurred in the house prior to me moving back home. I understood that I was responsible for anything from November 1st onward. I understand what you're saying about benefiting from not having rats in the house, but when they came to check, no rats were ever found.
Okay, so you didn't pay that bill?
No. It was like $2,000. Yeah, okay. Something insane and it's like, that's what he purchased before I even came home.
Okay. All right. I think that's it. Ms. Panich.
Thank you, Judge. Chelsea, on direct, Mr. Wiedemann said you were talking about not wanting to check on refis because it would ding your credit, or you were afraid it would ding your credit, right?
Right.
What is your credit score?
710.
Okay. Do you think you're going to have a problem qualifying for a loan?
Not at all.
Okay. Mr. Wiedemann also showed you the his amendment or submission from the marital balance sheet. Can you put that up, please? I wanted to go over that with you as well.
The one that.
Yes. So, okay. So I'm going to show you what, you know what, go back to the one he has, then I'll bring this up.
Just a second.
Sorry.
They didn't have it.
Okay. This is what Mr. Wiedemann showed you, right?
Yes.
P12. Okay. So if you believe that there's no equity since you don't own that car, right?
Right.
So we can take that. If we take that off, now the marital balance sheet that both you and Jeremy submitted were quite dated, right? They weren't the most recent balances, correct?
Correct.
Okay. Did you incur any other loans since submitting that marital balance sheet?
Yes.
Which one? And for how much?
I've incurred 2 loans from American Express. One for 30,000, one for I think it's 15,000.
Okay. Is the 15,000 included in the original marital balance sheet that we submitted? If I tell you it is, do you have any reason to doubt me?
No.
Okay. But the 30,000 is relatively new, right?
Yes.
Okay. So are you swearing under oath that your debt is an additional $30,000 due to American Express?
Yes.
And what was that used for?
Repairs for the home.
Okay. So so we would add, if I add a negative 30,000, because that's not included, and Jeremy Upstart, the bottom right before your student loan, is that the Martini company that we were talking about earlier?
I'm not sure.
Okay. He started a company.
He did.
You know what this $47,000 of debt is?
No.
Okay. So are you asking to hold on to any company that you and he started or he started during the marriage?
No.
Okay. So would it be fair to say that that's not really debt since he still has an asset, a company, a corporation that he's going to continue with?
Yes.
Okay. I'm going to show you what I'm going to call R17.
3, 7,
You do? Hold on. You may have an R17 already.
Go with R9,
We're
R20.
going to call it R20 just to be safe. Okay. So now I'm showing you what I've marked as R20 for identification. Can you look it over and see if it now reflects removing the Range Rover because it's leased, removing the debt of Upstart that you know nothing about, and if it is his company, he wants to keep it, and adding your debt, your loan.
Yes.
What numbers do you see on the bottom? What are the totals now?
For my column, it's 76,783.35. For Jeremy, it is 73,431.60.
Okay, so you may have just a little bit above 50%, and he would have just a little bit below 50%.
Yes.
Okay, Your Honor, I move R20 into evidence for demonstrative purposes.
Okay. You called it what now?
R20.
All right, so a minute.
You also mentioned in direct that every time you have court, there seems to be, I guess the family tends to tighten up and protect Jeremy. Is that fair?
Every time.
Okay. Is there a time that Jeremy told you there was no court before a court date?
Yes, actually the last court date that we had scheduled, that was rescheduled, he told me that we didn't have court, and that's when he took Wynn to daycare, and I had to be excused to go get her.
And you had told me that he thought there was no court, right? And I
Yes,
instructed you to tell him, no, in fact, we do have court, right?
yes,
And notwithstanding that, he went ahead and continued to tell you that there was no court, right?
right.
And what did taking Wynn to daycare do to you in your ability to attend court?
We had to ask the judge to be excused so I could go get her from school.
Okay. Was it a day that she normally would have been at daycare?
Yes,
Okay, but not to be picked up that early?
no, not to be picked up that early, no.
Okay. Mr. Wiedemann asked you if you expect to be working a very long time. How do you hold jobs? I mean, how long have you been employed by this company?
Since 2019,
And before that, how long were you at your last company?
about 3 years.
Okay. Has Mr. Knowles been able to hold a job?
Yeah.
Okay. Also, Mr. Knowles, we were talking about what Mr. Knowles had previously testified to at another hearing about your items being in a shed, but under air conditioned. Do you remember that?
Yes,
Okay. And he also said it was with your permission to put your really nice stuff up in the shed. Was that with your permission?
no,
Do you remember us having this conversation and it was like a legally blonde moment that your nice things would never be up in a shed with your permission?
yes.
Okay. And when you arrived at the house right after that hearing, what did you find?
Everything was outside, uncovered.
Okay. And the shed wasn't air conditioned, right?
There was no air conditioning unit at all. The window was open.
Okay. And your items had been left outside.
Yes, they were outside.
And was it the outside items that had the bites in them?
Yes,
Okay, not something in the house. It was outside stuff that had bites on them,
yes,
right?
yes.
Did you ever see a rat in the house?
Never did.
Okay. And I just want to be very clear. The
Did
items
you ever hear anything that could have been?
I didn't. And I even asked, like, every time they came and checked the traps at least 3 times and they never reported activity.
do you know when?
Dropping, no nothing.
Sorry, Judge.
Okay, go ahead.
Do you know when Jeremy signed that contract for the exclusionary,
I believe it was October 30th.
which was 2 days before you were supposed to move in?
Yes.
And he didn't tell you about it, did he?
Didn't talk to me about it. He didn't tell me there was a rat issue. Literally just someone showed up at the door, said, I'm here to check the traps. And I'm like, what? I had no idea what it was for.
Do you think this was a way for Jeremy to retaliate against you by putting a debt on you that wasn't necessary?
Yeah. It
Knowing,
did.
knowing that you would be responsible for items that he thought that would be your obligation at this point.
That's how it felt, because I feel like if he was genuinely concerned about my things being ruined or rats being in the house, he would have mentioned, hey, Chelsea, we have a rat problem. But he never told me.
Okay. Last question. The items that were in the contempt about him changing the renovating the house, your testimony is that they happened after October 11th, correct?
Yes.
You were in that house October 11th and saw and didn't have any problems, didn't notice anything out of place.
Yes, that's correct.
Okay, and in fact, if you recall, there was a video introduced already, where you, in late July, where you thought that that he was not very clean, right? That Jeremy wasn't very clean, and you panned through the kitchen in the house, right?
Yes.
See anything on that video, or was there anything on that video that caused you alarm aside from the just dirty condition of the home?
No.
Okay. I have nothing further. Thank you.
All right. No, and you said there were no other witnesses, correct?
Correct.
All right, Mr. Whiteman, do you have any rebuttal?
No, Your Honor, no rebuttal witnesses.
All right, then we're gonna do closings. You'll have 5 minutes to gather yourself and then we'll get started.
Here's what we're asking the court to do. First, obviously grant a divorce between the parties. I don't think there's any dispute over that. Second, as to the division of the property, I think it's generally, I think it's the case that the parties agree on the disposition and value of just about everything except for the former marital residence. As it pertains to the equity that's in the former marital residence, Your Honor, an equitable distribution does not mean an equal distribution. When you consider the path that these parties are likely to continue on after this divorce is granted, Ms. Knowles will continue to earn substantially higher than Mr. Knowles. She will have a probably long, fulfilling career at continuing to accumulate assets for herself and for retirement. And that is not equally the case for Mr. Knowles. He is in good health right now, thank goodness. He is in remission. He is generally in good health, but the court has to look at what his earning capacity will be in the future and consider that as an equitable factor, which is why we're asking the court to grant him more of the equity in the marital residence. This is a situation where both parties have far more debt than they have assets, and really the only asset that is divisible by the court is the marital residence. Even if the court were to consider an equal distribution to be equitable in this case, I think we've shown through the summary spreadsheet that I created that when you actually correct some of the errors in the respondent's marital balance sheet, there is an equal argument to make that Mr. Knowles should have more or all of the equity in the marital residence, even if the court considers equalizing everything. As far as possession of the marital residence, Your Honor, this house is uniquely more valuable to Mr. Knowles than it is to Ms. Knowles or to anyone else. Notwithstanding, Ms. Knowles testified she thinks that she can just assume Mr. Knowles's mortgage and keep the 3% interest rate. That's not, in my experience, how these things work, but I think that it's more likely that she would have to refinance, which means that she's basically buying this house all over again at the current interest rate, which is, I don't keep up with these things, but 7%, 8%, which would be essentially the same deal if she were to buy another house in the same area. She would be buying that house at the current market rate of interest. If Mr. Knowles has to buy a different house, he'll have to buy it at the current market rate of interest. Where he is right now, with being the sole mortgage holder on this house and having a historically low interest rate, this house, because of that interest rate, is more valuable to him than it is to anybody else, including Ms. Knowles, which is a reason why we're arguing it should be awarded to him. As an alternative, Your Honor, I would ask the court, if the court is going to award possession to Ms. Knowles, that obviously the court will require her to refinance or get the indebtedness out of Mr. Knowles's name. I would ask the court to give Ms. Knowles a reasonable deadline, perhaps 60 days, at the end of which, if she's not able to refinance, then Mr. Knowles has the ability to step in and just continue on with his mortgage and have possession of the property. So as a sort of standing in a second place. Your Honor, as to custody, I don't think the court heard any reason.
Let me back up real quick.
Yes, Your Honor.
When you said about the 60 days, you're talking about 60 days for her to assume the mortgage or 60 days for her to start the refinancing process. So for example, if she were to start it and everything is looking good, but it kind of gets pushed back for whatever kind of technical issues, was your position that 60 days would be over, but as long as she starts the process, or are you saying she must assume the actual loan that he has? Which one are you talking about? Assuming
Yes, Your Honor. Yes, Your Honor. I would say 60 days to refinance or get the loan out of his name. And if the court
his name, okay, whether it's assuming it or refinancing.
Right, and if the court feels that 60 days is too short, then I would argue that the deadline would be not I'm making progress or I've started the process, but that it's totally out of his name by that point, whatever the deadline is.
Okay, may continue.
Thank you, Your Honor. Turning to custody, I would say that the court has not heard any evidence in the last 2 days to deny Mr. Knowles joint custody. The guardian ad litem stated that she was confident that he had the competence and capability as a father to do multiple overnights in a row. I know I'm going against the guardian ad litem's recommendation, but if he can be trusted with 35% of the custody time, I don't see any reason why he can't be trusted with 50% of the custody time. Your Honor, I think also he is capable of joining in decision-making, and that the court heard evidence why he needs the protection of having some decision-making authority in the parenting plan. So we're asking for a parenting plan fashioned by the court to give the parties joint legal and physical custody and to have some sharing of the final decision-making. Alternatively, I would suggest to the court, if the court were considering the guardian ad litem's recommendation, the guardian ad litem's recommendation was for every other weekend, Friday night, Saturday night, and Sunday night, and then Tuesday night and Wednesday night of the off week. I would ask the court to consider making that Tuesday night, Wednesday night, and Thursday night of the off week. So 3 overnights per week to Mr. Knowles. That is not 50-50, and he would, of course, treasure any additional time with Wynn that he possibly can be granted, but I would be asking the court to consider just adding one more overnight to the guardian ad litem's recommendation. Your Honor, looking at the issue of child support, however the court fashions the parenting plan, Mr. Knowles will have a very significant percentage of parenting time, and we're asking the court to enter the child support worksheet with a downward deviation for that considerable parenting time that he will be exercising. Your Honor, in terms of attorney's fees, the argument that I think that I heard from Ms. Panich was that we should have to pay attorney's fees because we didn't accept their settlement offers. And Your Honor, we're free not to accept settlement offers. That's, Your Honor, that's why they're settlements. And sometimes the parties don't come to a meeting of the minds and they don't settle cases. And then that's why they find themselves having a final hearing. Your Honor, I'll tell the court, we made settlement offers as well that were not accepted by the other side. That's usual for a divorce case, especially one with as many moving parts as this has. The overall policy reason for reapportioning attorney's fees in cases like this is to level the playing field, to give litigants an equal ability to be heard in court. And from that point of view, it's Mr. Knowles who needs the assistance of attorney's fees, because Ms. Knowles, at the time that they were separating, was making about $8,000 more a month than he was. So to level the playing field, Your Honor, we're asking the court to apportion at least some of our attorney's fees over to the other side. And then finally, Your Honor, and I don't want this to be the tail that wags the dog, but the contempt issues that were filed last year that went back and forth, Your Honor, heard extensive testimony about this. He was supposed to be out of the marital residence by November the 1st. He made attempts to comply with that. He had all of his stuff packed up, all of his stuff out on the front porch or in the carport. He was trying to get it transported away. Yes, he probably should have moved faster, or he should have started earlier, but he was attempting to comply with the court. Ms. Knowles is not coming to the contempt with clean hands. There was a great deal of testimony about whether adding locks to a door is the same thing as changing locks. And I guess you could say that the original locks are still there, but when you add additional locks to the door, you're making it not possible for that person to get through that door. So I think that's being a little overly particular. And she did admit that there were calls that she did not return, that there were at least multiple calls that she did not return. Your Honor, I think like many cases that probably come before the court, this was a long litigation. It was very stressful. The parties, perhaps both sides, did not act with as much grace as perhaps they could have or should have been expected to. But I think in the final analysis, I think that the contempts, I would say, cancel each other out. And I would ask for the court not to be holding my client in contempt, especially when we can show with many of these issues that there was efforts to comply with the court. And so those are the things that we're asking for the court today, and we appreciate the court's time over the last 2 days hearing the great volume of evidence that was in this case. Thank you.
All right, thank you, Ms. Panich.
Thank you, Judge, I've been doing this a long time. I'm constantly still gobsmacked by parties who, in their first divorce, think that they know better than the judges and the lawyers who've been doing this our entire careers. And think that they can get one over on us because they're too cute by half, or they just don't feel like following the order, but they feel like, you know what, I don't have to follow the order. That's what happened in this case with Mr. Knowles. He's one of those parties. Every single time we
I'm
went to
sorry, one second. Mr. Knowles? Mr. Knowles? Ms. Marshall, did you get a chat?
No, ma'am.
All right. Go ahead, Ms. Page.
every time we went to court, he tried to undermine Chelsea. Either he told her straight out, there is no court tomorrow, and set her up in a way that he didn't, that she was now responsible for picking up Wynn, even though that wasn't her responsibility wasn't supposed to be her responsibility. He tried to undermine her. On top of which, every time we had a setting, which were multiple in this case, we had 2 temporary hearings, but we had 3 settings for temporary hearings. One that just the court was still in their criminal calendar. We were able to resolve the issue ourselves, but we had to be geared up for trial or for hearings 3 different times. Each time we made recommendations. Each time we made something reasonable based on what we knew at the time, that Mr. Knowles was having an alcohol problem, that he was having problems with his MS, or actually we didn't know if it was alcohol or his MS, and that we knew that the guardian was going to give primary physical custody, or the court was going to give primary physical custody to my client. And that's what happened every time. And yes, people have a right to go to court, but people also have a right to make recommendations that are reasonable and be accepted. So resources aren't wasted by going to court repeatedly. The court has heard, well, the motion for attorney's fees for the first 3 hearings. My client received primary physical custody from Your Honor. My client also received the marital home. I will read from that order because Your Honor made findings of fact, not temporary findings of fact, but findings of fact. So when Mr. Knowles comes back and says, I think I can have the house, this is what the court said. Respondent left the marital residence in December 2021 with the party's minor child due to a domestic violence incident between the parties. That's one of them. This court finds that it's in the best interest of the minor child to return to the marital property or marital residence. So the court made a finding that the marital residence generally goes with the child, and my client was going to have the child primarily. So from the beginning of this case, it was clear, and essentially if the guardian was going to recommend the same thing, that primary custody stay with my client, that this house shouldn't have been an issue to have to deal with. The only issue is, how much does he get paid out from the house? And he has refused every reasonable offer. And related to the guardian, they agreed to have a guardian in this case, Judge. We got one appointed. She did her evaluation. Every step of the way, my client was to have primary physical custody and tie-breaking authority. So there, based on what Your Honor had done with primary physical custody, there was never a time where Mr. Knowles should have thought that he was going to end up with primary physical custody or even joint physical custody. That was not something that Your Honor did from the beginning. And there was no reason to believe that that would change, that their trajectory would change. Mr. Wiedemann specifically asked the guardian, is this a 50-50 case? Could this be a 50-50 case? And she said no. She is the officer of the court that no one seems to have a problem with, because she did a very thorough job. She investigated everybody. She dealt with all the sober links. She talked to Jeremy's doctors. She talked to Wynn's teachers. She did everything above and beyond what a guardian should do. And her recommendation is that my client continue with primary physical custody. And that never wavered. So the house and the primary physical custody were never really, or should never really have been at great issue. And yet we made offers back in July, so we didn't have to have the August trial, to say, look, just go with the guardian. I mean, just go with what they've been actually doing. And had he taken that offer in July, they'd still be doing every other day. Now, obviously things changed. The child had other needs. And so now we end up in a position where the guardian has changed their recommendation to every other weekend and 2 nights during the week. The guardian's recommendation was specific to 2 nights during the week, not 3 nights, not 4 nights on the off week, 2 nights. That's what she believes Wynn can handle. Chelsea has always allowed Jeremy to have more and has encouraged him to have more when it's available. But this is not a joint physical custody case. It was great that Jeremy stepped up when Chelsea's dad was dying. That's a wonderful thing. He's a parent. It was a great thing. It's also a great thing that he is in remission and that he has gotten his alcohol issue under, he's handled it. I think these are fabulous steps and fabulous things, and only portend for good things moving forward. But there was never a time in this case where it was a joint physical custody case or him having primary physical custody. To go through more specifics in this case, I need to point out what we saw evidence of yesterday with this. I don't have an obligation to pay the tuition. I do have an obligation to pay. I paid. I didn't pay. He has twisted himself into knots. And not just this hearing. If the court will recall, at the very beginning hearing, I asked him, and it's in the transcript, starts at page 119, do you have a problem with alcohol? He said, no. And then it later went on to be, I did have a problem with alcohol, but I don't anymore. Yet I went to rehab for coping skills related to alcohol, but not an alcohol problem. The court called him out. The court, because you also handle drug court, understood that this is ridiculous, but he cannot seem to answer a question in a straightforward manner. And the best illustration of it, well, another illustration of this was the stuff in the AC storage. He said it was he said Chelsea's things were in storage under air conditioning. Chelsea literally went over there immediately after his testimony and showed you video of what actually was going on. Her items were outside under a tarp, not fully covered. She testified that her items were damaged. He lied right to the court. He said it was under air conditioning. You saw the shed that allegedly had air conditioning. It was a hole in the wall. There was no air conditioning. And he wants you to believe that she would allow her nice things up in a storage shed with her permission. That's insane. But he doesn't seem to know how to answer a question straightforward. And when the court finally took over yesterday and said, what is your position on whether or not you have to pay for tuition or not? And he said, I'm thinking. He didn't know. He couldn't figure out what it is the court wanted him to say. But the entire time before that, the 15 minutes before that, he continued through this, I owe, I don't owe, I paid, I didn't pay, it's daycare, it's not daycare, it's school. I mean, things that are just blow the mind. And that's also why he cannot have tie-breaking authority on any of the grounds. We heard that Rachel Platt said that my client should specifically have it over education, plus the other two that she had already designated. And he wants religion. Why does he want religion? Who knows? He didn't say. It's not that he has a divinity degree or that they practice different religions. They practice the same, or it's not a non-issue with the two of them. They could do with it with Wynn what they want on their times. But to give him any tie-breaking authority would undermine her ability to parent completely, because he's going to use this as a control mechanism to keep her in line or to do something else. Now, his issue about wanting tie-breaking authority is because, and listen to this, they discussed the issues and she ultimately disagreed with the ultimate, she made her ultimate decision. Isn't that exactly what we want our parents to do in these cases? We want them to discuss. They both have joint legal custody. We want them to go through the issues together. We want them to collaborate and come up with a joint plan if it can be done. But at the end of the day, just because she didn't go with his every recommendation doesn't mean she's abusing her tie-breaking authority. The court saw example after example of Chelsea reaching out, Jeremy denying it first. She never told me about Wynn's behavior problem until that day or the day before in September when she went back to the order. We saw a text back from June 30th. She says, I need to talk to you, or we need to communicate because this Wynn's behavior is not doing well. And we need to figure something out. And he flatly refused. He flatly refused. So what is she supposed to do? She is the tiebreaker. She needs to make the decision. And even when she said, let's go back to the order, and even when she had me tell Mr. Wiedemann, we're going back to the order, please alert your client, he still said no. He refused to return her. He didn't say, I'll meet you here or you can come here. No, he said you can't come here. And then later he said you can come here after she was already supposed to be there. So my client had no option for somebody who refuses to listen to court orders than to involve the police. And unfortunately, we determined in that event that Mr. Knowles had missed his own court hearing. He missed his DUI hearing and had an FTA. He had an FTA from from May. He told you that himself. And now it's still pending. He doesn't listen to court notices. He doesn't care about court orders. This is a constant problem. And when the Guardian said that Wynn is starting to have a problem respecting authority, it's not that far a leap when she looks at her dad, who doesn't respect authority and doesn't listen to any of the court's orders. He comes up with these excuses. Well, the property was outside, but I left by November 1st. I mean, that's insane. Your Honor ordered him to vacate. That includes his stuff. And it didn't just say the interior of the house, but not the exterior of the house. It says the house. That includes the curtilage. He had no business leaving his stuff there. But he did it because he didn't care. He told Chelsea after she said, what are you still doing here? That she's a tenant and that it's his house. And in fact, we heard the same demeanor when I went over the marital balance sheet with him, where it said entirely that the marital residence should not only be his, but all the equity in the house should be his as well. And he said it was an oversight, except that Mr. Wiedemann just made the entire argument that equitable distribution requires that he get the entire house or most of the house. So it wasn't an oversight. He believes that house is his. And when I asked him about it yesterday, he said, well, I owned it prior to marriage. They both owned it prior to marriage. She put down half the down payment prior to marriage. He thinks it's just his. It's not. The law is not that. And I know his lawyers are too good not to have told him that. So it's his demeanor that he says he's above the law. He'll do what he wants. He'll do it when he wants. And he doesn't care what the consequence is. And because of their disparate earning, he now thinks that she should pay all of that, all of the delays, all of the refusal to communicate, all of the refusal to cooperate, and to come up with a resolution in this case that is what's best for Wynn. In this case, all we've heard is what's best for Jeremy. The Guardian is the one who testified about what's best for Wynn. It was her recommendation based on her investigation, based on agreements between the parties to have a guardian ad litem. He should be paying her fee, at least for yesterday, in its entirety. I think she billed $700 total, $350 a party. I would like that reapportioned. So Mr. Knowles should be obligated to pay that. He dragged us all in here, and he didn't bring up any new evidence. He didn't have her teachers here. He didn't have any other witnesses here. He didn't have his family testify. No one, just him. I think it's better that I have 50%. And that way I don't have to pay child support, by the way. That's not what any of this case has ever been about. And that's not what's best for Wynn, according to the guardian. Your Honor, Mr. Knowles is willing to remove his child from the marital residence because he thinks it's his house. Notwithstanding, the court had made a factual finding that the house generally stays with the child and that Mrs. Knowles had primary custody, and there was no reason to change from that. So what we want after the court has heard all of this is to adopt the guardian's recommendation, adopt our client's parenting plan, which mirrors the recommendation. The issue about extracurricular activities, my client has no problem allowing Mr. Knowles to have to choose an extracurricular activity. That doesn't give him tie-breaking authority, but she doesn't have a problem with it. She's acting under it right now, which also goes to, she does take his feelings into account and his thoughts into account and his suggestions into account, because she is in soccer. If she didn't want him to be involved, she'd say, nah, no activity, or only my activities. She's also taking Wynn to soccer on Saturdays, which isn't required because it's during her time, but she's doing it anyway because she's acting in the best interest of Wynn, and she will continue to do that. And again, doesn't have a problem with Mr. Knowles making a choice for extracurricular activities. We want her parenting plan. We want our child support worksheet. Mr. Knowles is trying to have it both ways. He says he wasn't fired, and although he didn't get any severance for being at the company for several years, and he's suing for, I guess he wasn't laid off. He's saying that he was fired for some type of nefarious reason, maybe because they violated his rights under the Americans with Disabilities Act. I don't know. But he's also choosing not to work. He hasn't done anything. He hasn't gotten a job. He hasn't tried to do anything. He's not driving Uber. He's not doing anything for, looking for sales jobs. He said he did the minimum he had to do to get unemployment for 12 weeks, and that's it. He's now applying for SSDI. Who knows if he's going to get it, and it could take years to have a result, but he's not looking for work in the meantime. He is capable of working. He didn't tell the court, I'm having more problems, more lesions. In fact, we heard the opposite. He's just choosing not to work at this point. He has an MBA, he's able to work, and I'm happy he's able to work. And he should live a long and healthy life. But he has the capacity to work, and he's not even trying. So we're asking you to impute the income from what we know he can make, which is the $13,000. And if in the future he gets disability, then we'll be back here on a modification, I am sure, if Mrs. Knowles won't voluntarily reduce given his current situation at the time. But right now, he's doing well. And he's just choosing not to work. That's no different than any other parent saying, well, I'm going to quit my job so I don't have to pay child support, which we hear a lot. So, or voluntarily underemployed. Right now, he's voluntarily underemployed. We're asking my client to keep the house, provided she can refinance. We're asking for 120 days, Judge, for her to either refinance or assume the loan. She will pay 50% of the net equity using the appraised value from the bank, because the numbers that we have may not be the real number, and we won't know that until this house is refinanced anyway, and the market can change from here till then. And so to put an amount on it right now wouldn't be fair anyway. I would ask that we adopt what the bank's value is, either for an assumption. If there's no assumption, if she can assume it and they don't require an appraisal, then I would suggest that both parties each get appraisals and they use the middle one. They average it. But he should get 50% of the net equity of the appraised value that the bank requires. Plus, she should get credit for the principal that she paid in. I acknowledge that the number she included, the escrow, I understand why she included it, but it should have just been principal. And half of the repairs that she was forced to make because he decided after the court order not to touch it, to touch it. He didn't present any evidence or testimony that these items were fixed or renovated before October 11th. The only testimony we heard about it was my client who said, I was there on October 11th. I didn't notice any of these things. And they only happened after. So she should be able to get half of those repair fees back. In terms of assets and debts, that they should each keep what's in their name. The issue about this upstart, which wasn't in his marital balance sheet, Chelsea's the only one who testified to it. It's a money-making side venture. She had an interest in it. If this is the martini, if it's not, we don't know what this is. But and we asked for discovery. I mean, we've done discovery, so we're both under an obligation to supplement, and we didn't receive anything more about what upstart might be. We're asking if he's keeping this, which I assume he is, that he keeps whatever debt or asset goes along with it. She doesn't want it. As for attorney's fees, Judge, I've gone through it, but the statutes are 1993. The statute that we're talking about is 1993, which is the judge may order reasonable fees, attorney's fees and expenses of litigation, expert in the child's guardian ad litem, and other costs of the child custody action and pretrial proceedings to be paid by the parties in proportionate times determined by the judge. They may be awarded at both the temporary hearing and the final hearing. The court has wide discretion to award attorney's fees under this statute and cannot consider the financial circumstances under this statute. We had 3 lengthy hearing settings. It cost Ms. Knowles a substantial amount of money, $18,000 for the first 3 and $26,000 since. You can see that both parties have spent about $70,000, but until, and again, I don't know how the court's going to rule on this, but previously, Mr. Knowles did not prevail on a single position, not one. So not only were we asking not to pay for his attorney's fees because of his behavior during the litigation, but also that he pay her fees so we don't get dragged into court repeatedly for unnecessary things, which I expect will happen with a 3-year-old child. They have a long way to go. And I expect we're going to see modification after modification by Mr. Knowles as often as he can file. But he has to know that there may be a consequence, there is a consequence for frivolous litigation. And depending on the court's ruling, we would likely file a 9-15-14 after this. One moment, Judge, I just want to make sure I covered everything. Oh, on the contempts. On his contempt, the only person who testified as to what was said, because she was there, was Chelsea Knowles. And apparently they may have had a video about this and chose not to introduce it. So lack of evidence for this allegation of disparaging conduct. If they had a video, they didn't show it, which begs the question, why not? The other issues on his were that she didn't allow them to call him to return the call. There was no evidence presented. And Chelsea gave a reasonable explanation about when he called after 7. It didn't, that she wasn't obligated to call back. The locks changed, the lock still works. And there's one lock at the garage that the court saw a picture of taken this morning that shows that lock works. Mr. Knowles testified himself that he didn't even try. So he doesn't know if it was changed or not. I mean, the fact that he saw an additional lock doesn't mean that the one was removed. And in fact, I asked him, was the key lock on? And he said, yes. We saw in the pictures, it wasn't. His testimony is not credible. And the Arrow expenses, we heard from Ms. Knowles that contract was signed 2 days before he left when he knew he was leaving. There were no rats in the house. There may be some wildlife outside, which makes sense, which is what tore up her things because they weren't secure in the shed. or anywhere. But it was, she should not be responsible for that arrow. If there were rats, sure, maybe, but there weren't. We don't know that he didn't just sign her up to make her responsible for it. He was definitely as petty in other times. Our contempt. I think Mr. Wiedemann's argument is no harm, no foul. He was out of the house. But his stuff was on the porch. It took, Miss Knowles said it took almost 10 days before all his stuff was gone. So he was coming and going from that house for 10 days. This court had a phone conference with the parties on November 10th to discuss this because he refused to leave. At that point, the court said he doesn't have a reason to come back anymore, except that he did. He just kept coming back. So he violated. The fact that there's no harm doesn't mean that he's not under an obligation to comply with a court order. And there was harm. She wasn't allowed to live in peace with her daughter at the house that this court awarded her. The renovations we've already dealt with, the mortgage info. He knew because we sent him an email, which is in evidence. We sent his lawyer an email, Ms. Wise, on November 1st and said he's not leaving or he hasn't moved. Plus, we don't have the information for the mortgage. On November 1st, she knew. Had we just gotten an email right after that that said, okay, here it is. Sorry, there was a mix-up or I had to reset the password, we wouldn't have added it to our contempt. It's because he chose not to. That's what he was doing. He was playing games. And the fact that she paid the mortgage by the mortgage date is another no harm, no foul argument. And if the court wanted it to be that the mortgage needs to be, that the password and the username needs to be submitted to Ms. Knowles so that the mortgage is paid in time, the court would have written it that way. But the court didn't. It said by 9 a.m. on November 1st, and it wasn't done. We're also asking the child support to be caught up with and him to pay what he owes immediately for tuition. Judge, there are cases where there are good faith disputes and the only person to resolve it is the court. In this case, this is not an unusual type of case. It's a case that should have been resolved in mediation, and especially once the guardian came back with a reasonable recommendation. We should not be here. We should not be spending their resources. They are both in significant debt, and this is just adding to it. But my client has spent over $45,000 of the 70-something thousand just dealing with him going to trial after reasonable offers were made that were rejected. And there were not constant counter offers. We got one, which asked for more than 50% of the marital residence. I said, send me the invoices to prove that he's entitled to more than 50%. Didn't get anything, not a thing. So they were not acting, I'm not talking about the attorney. I'm talking about Mr. Knowles, was not acting in good faith at any point in this litigation. He just wants to drag it out, and that's why we're still here. Thank you, Judge.
All right, thank you. Give me a few minutes. All right. So I'm gonna make some rulings and others I'm gonna reserve on until I've had an opportunity to kind of dissect some of the spreadsheets that were presented to the court. But I think the main issue, at least started out, was the concept of who would be a primary physical custodian of the child. The guardian ad litem has indicated that that should be the mother. The evidence in the case indicates that that should be the mother. So the court is awarding primary physical custody to Ms. Chelsea Knowles, and father will have secondary with the timeframes that are outlined in her report, and also reflected in the respondent's parenting plan. I think that the time frames that set out from Friday to Monday, and then this off week and overnight, and return to school, I think, on the second day is very reasonable, very good outcome in consideration, particularly the fact that you all live so far apart. I don't know if those circumstances still remain the same. But I think the drive, I can imagine a child being switched back and forth for that length of time would be considerable. And I'm just, to some extent, even surprised that it would even be considered without somebody moving, or even the idea that there would be moving closer. Because there's just no way that, even if you had come to me and you all had presented that to me, I probably wouldn't have done it even so, because I think that's a lot to put on a child. And generally when you do that, it's because the parent wants to spend time with the kid, and we get it, but you also got to understand the kid has to come first, and that going back and forth on a day, every other basis is just too much, even for a 3-year-old. I do think a 3-year-old needs consistency, and I think that might be the reason why she's acting out. She has a whole different circumstance. Life is basically turned upside down for her, and that might be the reason she's lashing out or behaving differently. I don't know. I'm not a psychologist, but I see a lot of that when you have parents divorcing and children are young and they don't quite understand why the dynamics are very different for them. And so I think, based on what the guardian ad litem has indicated, quite frankly, that's an easier decision for the court to make. And also, as Ms. Panish pointed out in the presentation, I don't think there was anything that was inconsistent with that the child would benefit for that type of schedule, other than the fact of seeing her father. But I think the way that we're setting it out, she'll have that opportunity. And if you all continue in the light that you're going, there'll be a lot of flexibility in how you do things, and hopefully more time will be granted when possible. But I think when you have that much distance in between you, it becomes very difficult. I always applaud parents that can stay closer with each other. You don't have a parent after divorce moving to Kennesaw and you're living down here and you think you're going to have this real easy exchange of the child. It's difficult. It's going to make lives miserable. And so sometimes, in those situations, I just wish I could shake them and go, you got to put the kid first. If you don't have a reason for moving there specifically, try to think about your kid and stay close so that you can, rush every now and then and catch basketball games and go to after school activities, because you're not an hour away. So anyway, I do agree with the guardian ad litem's recommendation. And I do think that the time periods that she set out are good, and particularly in light of what could be Windsor behaving that way as a result of the change of circumstances and some consistency. I think it's actually good. I think Mother bringing that to father's attention and wanting to do things differently as a result of that speaks volumes as well, even though at one point she was very willing to do the schedule that Mr. Knowles presented. But I think at some point she recognized that did not appear to be in Windsor's best interest, and perhaps stopping that and doing something else to see makes a lot of sense, and the court appreciates that. Along those lines, there are certain things, and I generally, when I have these hearings, I don't like to be too one-sided where I'm talking too much about mom or too much about dad, because I think you need both parents. And when you're in the situation where you're divorcing, everybody has some involvement in what causes the divorce and those things. So I don't really like to point out too much one particular thing over the other. But I do think it is important for the court to point out a few things. I think that from what the court sees, mom's approach appears to be very reasonable. And I don't think so much for Mr. Knowles. I think Mr. Knowles' approach on various things is very concerning to the court. And it makes me have doubts about his credibility. I think when you have a circumstance where you can't articulate, you're saying you're paying daycare, but then it's kindergarten, and it's not kindergarten, it's something else, and you don't have to pay it, and maybe you have to pay it. Let me think about it. I'm not really sure. Did I pay it? I say I didn't. I said I shouldn't pay it, but then I send money saying it should be considered. It's all over the place. And it causes me a lot of concern when you cannot be consistent about something as simple as, did you pay childcare, or did you pay whatever you call school fees of a child that's not old enough to go to any public primary school? It's not like you can take her and put her in a kindergarten program that would be free. No matter what, you're going to be paying for daycare or primary school care, or however you look at it. And you agreed to do it, and at one point, or indicated you were going to do it, and all of a sudden, because she went from one class to another class, from a kindergarten toddler class to a primary class, all of a sudden the obligation stopped. I don't understand that rationale. I don't understand that reasoning. And I don't understand how you, but when I asked you to articulate it, neither did you as well. And so that kind of concerned the court. When I have that type of thought process, it makes me wonder, how reasonable can you be on various other things, such as even the dentist issue. You go to the dentist and you got a phone call. You think your child is having her first dentist appointment. Of course, you're excited. You want to go see. You think the mom is not being truthful. You go to the place, and there you hear a voice, and you go to the back to check it out, and she's in a restraint. And it's a stroller. You use the word restraint, and she's in a restraint chair. Like, is she getting dentist work done? And I think you kind of knew from the beginning she wasn't getting dentist work done. And when I asked you, because I stopped you when you were saying that, I said, was Windsor at the place? Yes, she was at the dentist's office, Your Honor. Without the added part, well, but I recognized at that point that she was not having service done. And let's be honest, you could very well know she had service done, because you would have been able to ask the doctor, did she have service? Because you're the dad's father, you're the father, and you're the primary on the account. So you could have figured that out immediately, whether Windsor was getting service done. And so when you came to the court to bring up that issue, why bring up an issue that you already understand the end result is she did not get service that time? Because you went to her dentist appointment later on in that year. So why would you bring up this issue that she lied about going to a dentist appointment that you already know did not happen, and you actually went to the first dentist appointment? That concerns me, because I don't understand the purpose of it. Why bring up the idea that your wife lied about a dentist appointment when you got there and the child wasn't in the chair, but was in a stroller, for which you took her out the stroller at the dentist office? And you could very well say, did she get her teeth done today? And I don't think you would have avoided that question, to ask. I think you left that place recognizing that she did not have service, yet you bring it up to me to muddy the waters as if she did. And I don't like that. I don't like it. That doesn't give me comfort that you're going to be reasonable with your expectations, that you're going to be reasonable with your decision making. And then we go on about the moving issue. You knew 30 days in advance on the moving issue, and all of your stuff is there. But here's what concerns me the most. And I have a may not remember names, case numbers, but I have a very, very, very good memory. Okay. And I know specifically at that meeting, at the hearing we had, you showed pictures of the black and yellow what do you call it, bins. And you told the court that her things were in those bins and that you had put them in a garage, in a place that was AC, that was that they were being properly stowed and cared for, and that nothing was outside. You specifically told me that. And I made sure, and I asked you over and asked you a volume of questions related to where her clothing was. And you doubled down that her clothing and her items were in a safe place. I'm sorry, if y'all give me one moment. And then the whole issue about returning the child. You know, she was like, okay, we're gonna go back to the old way. And you're like, no, unless you also do this and that. I just don't understand it. It's just unreasonable. You're taking an unreasonable position on things. And that unreasonable position, I don't know how you can't see it. It's causing your attorney fees just to be exorbitant because your positions that you're taking on these matters are just unreasonable. There's no reason for you to have gone back and forth over the order. The order is what the order is. If I've ordered it, you're supposed to do it. And if you guys change it, that's one thing. But I'm going to hold you to that order, right? So the fight over it doesn't make sense to me. I don't know. Consequently, for like I said, I'm going to follow the rec of the guardian ad litem, and mother is going to make all final decisions regarding the child. You will have discussions, but her decision, she will have the final decision-making authority. You will have one opportunity to select an extracurricular activity that does not interfere with the activity that the mother has selected. Now, what we're going to do is for that, I'm going to give some consideration because sometimes what I like to do is I would like to give one person an opportunity to find, you know, whenever you find that extracurricular activity, we got to be mindful of making sure that it's not overly burdensome on the person that has to take them, whether or not you can grab them and take them and still get them home where they need to be. So those are some considerations that I need to have to think about with regard to the extracurricular activity so that you'll be able to select extracurricular activity as well. With regard to child support, I am going to impute child support based on mom's child support worksheet as well. I think your testimony regarding even your work, it's not consistent. You say you're in remission and that you don't have any issues and that it does not affect your ability to parent, and that you're the highest earner at work and you're doing everything you're supposed to do at work and you have no idea why you were let go. But then in the same vein, you said, well, I'm going to sue them because they must have let me go because of my medical condition, which could be, I don't know how often you were late or what you were doing. So I'm not sure if that was a consideration or not, but it feels inconsistent. Like if you're doing everything you're supposed to do at work and you're meeting all your goals and exceeding them, and because you're late for work or you're not coming to work, they're going to terminate you, no severance. And the reason why they're doing that is because you're sick, but your sickness or your illness does not prevent you from performing, which is what you said. It's inconsistent. And then as a result of that, your position is I'm suing. And then outside of suing, I'm only going to look for certain jobs, but it's going to be very difficult for me to find these other jobs. You have a master's and you're not even looking in other areas, even outside of what you're doing now. If you have a master's, you could be able to do other jobs. But if your decision, the thought was, well, I want to go on disability, but for what purpose? Because I just asked you, were you able to do these jobs? And initially you were like, yes. And then I think on the last question, somebody asked you, I think you said, well, maybe not. I'm confused because you just said you were the highest earner and you were doing everything you were supposed to do on that job. And you have no idea why you got terminated or why you were laid off. It's just more of the same. Like, I don't know if I can trust what you're saying. And it might very well be, you might actually have some some issues as a result of your condition, even though you're said you're in permission that, you know, that we're not being mindful of, but it's just, you're just inconsistent. You're inconsistent. And it's almost as if you're inconsistent because, and I hate to say it, it's almost like you think you're kind of smarter than the whole system. And you're making up stuff that doesn't, it's not gelling, it's not making sense, and it doesn't come off well. If you are found to qualify for disability, obviously you'll file a modification and we'll deal with this. But until that time, you need to look for a job that based upon your education and your experience. With regard to the property, although the property was purchased prior to the marriage, I think the documentation shows that this was considered to be a project that you were doing, even though prior to the marriage, but for the marriage, your anticipated marriage. The gift letter indicates, and you presented the gift letter indicating she was your fiance, and then you all shortly married thereafter. So I do believe, Ms. Knowles, that if it was considered marital, it certainly was commingled. Excuse me, if it was considered premarital, it definitely was commingled as you're in at some point, and there's a equitable interest. I'm going to determine how that's going to be done, but I am going to give the home to mother, and I will give her 120 days to refinance and or assume the loan, and if not, then you'll get 120 days to do the same, to buy her out, and if you cannot do that, then it'll be sold. You'll pay the remaining amount of tuition that you have, and you'll pay the remaining amount of child support. You have 30 days to pay that amount of funds to catch back up. I think this is a short marriage. And so although Mr. Knowles has a medical issue, first of all, the issue, it's in remission. And second of all, the marriage is just too short for the court to give a considerable amount of weight to with regard to their retirements. I'm going to hold off on that issue, though. I'm going to look at it and make sure it is there. But initially, at this point, my position is that everyone keeps their own retirement. But I'll take a look at that when we follow. For the contempt, court grants mother's motion for contempt. Kind of already gone over those issues. I just think that I don't understand some of the things, decision making. If you go to the house, you notice that there is a lock on the door. There's another lock. There's another door that looks exactly the same. Just try the door. No, I mean, just try it. While we're here in court, you spend thousands of dollars when just trying it with the key would have saved you all of that money. I just don't understand. There's no evidence that mom made a disparaging remark against your mother. I know they said there was a video. I didn't look at the video. No one said anything inconsistent with what Ms. Knowles indicated, which that she did not say anything on the video. However, regardless, I think it's important that neither one of you say anything disparaging against each other or each other's family. We'll make sure that's in the order. Ms. Penn, make sure that's in the order as well. Okay, I think so what I'm withholding on is how to consider the pensions and any of the debts. I'm gonna look at those worksheets that you all sent me. So the pensions, 401k, and the debt, I'm gonna take a look at that. As to what I'm gonna do on that. And for the attorney fees, I'm also gonna grant mother's motion on the attorney's fees with regard to the 3 hearings. Like I said, I just felt like most of those hearings, we were dealing with stuff that was just unreasonable. I just don't understand why stuff it was just making things difficult when it was not necessary. With regard to the guardian ad litem, I think everybody will pay their own fees minus the guardian ad litem's testimony in court. Those fees will be paid by Dad. I would want each person, each attorney to send me the list of the of your exhibits that were actually admitted into court. So send me that list of the ones that were admitted. Send that to me so I can compile it for appellate purposes. Any question on anything that I've indicated for my tentative ruling? Yes, Ms. Spanish.
Judge, you indicated that my client would buy out, assuming she qualifies, would buy out, pay out Mr. Knowles, but you didn't give a percentage.
Yeah, I said I want to take a look at all those real numbers.
Sorry.
Once I look at, because I want to look at the debts and and some of the assets. I try to do pretty good notes on any of the loans and what the loans were for and stuff like that in my notes, but I need to kind of compile it all together because it's just a little bit too much for me to kind of do it right now. So I need to take a look at that. I took screenshots. So, and I also have your other stuff too of the ones that are most important to me anyway. So I'll go back and take a look at those and I'll let you know what I'm going to do on those issues.
I have a couple more questions.
Mhm.
For Your Honor said you granted the first 3 hearings for fees. Is the court making a ruling on where we are today? Because that was the first motion that we filed in November.
Yeah, I granted your request for attorney's fees.
Okay. And then, Judge, I would ask for a Franklin ruling in the that makes the final ruling a temporary for purposes of appeal.
Oh, okay. Yes.
Thank you.
Do you put that in the order?
Yes, Judge, and I can send the court, I can, when I draft the order, I can put some language in.
Yes, you can start preparing the order. You can send it to us and the things that are blank, we'll fill it in. You can send that to Ms. Harris. Ms. Harris is my law clerk. Ms. Harris, if you would put your information in chat for Ms. Panich.
Yes, ma'am, Judge.
Mhm. All right, that's the order of the court. Y'all free to leave.
Thank you, Judge.
Thank you, Your Honor.
I can't leave until Ms. Harris sends me the information. Thank you.
I got it.
John, are you going to send us a bill? Or,
Sure, yes, I'll do that. I'll send no transcript at this point to either party, and y'all are just gonna split the appearance